Welcome to the Tejswi IP Show. In this podcast, we dive into the world of intellectual property, like patents, copyright, trademark, geographical indication, and design. We also analyze recent events in the IP world. Today, we're bringing you a special review of the most impactful intellectual property news from July 2025. We have gathered some truly fascinating updates that could shape the future of innovation and creativity globally.
That's right. And what's really interesting is just how quickly the landscape shifts, whether it's through landmark court decisions, new legislation, or just the sheer volume of innovation from leading companies. We're going to explore these shifts and what they truly mean, trying to help you navigate this ever-evolving world of IP.
Okay, let's unpack this. Our mission today is, well, to highlight the most important nuggets of knowledge from the past month. We're talking patents, trademarks, and copyrights. You'll get a real shortcut to being well-informed, maybe with some surprising facts and crucial context along the way. Think of it as your essential update for staying ahead in the IP game. Right, so we're kicking things off with patents. They're always kind of the lifeblood of technological advancement. And what a month it's been. We've seen a significant ruling from China and some incredibly interesting trends in how companies are building and protecting their patent portfolios.
Indeed. Patents are really the bedrock for innovators, right? And their protection, or maybe the nuances of that protection, it directly impacts market dynamics. It influences everything from product development cycles to global market competition, even supply chain decisions.
First up, the big news out of China. The Supreme People's Court there has upheld the invalidation of a high-efficiency video coding patent, HEVC, right?
Yeah, HEVC.
This patent was originally held by U.S.-based GE Video Compression, and is the culmination of, a 3-year dispute initiated by the Chinese tech giant Xiaomi. Now, HEVC is crucial for high-quality video streaming, conferencing. It's everywhere, so this isn't just some technicality. What does this decision truly signal for global tech manufacturers, especially, those in the smartphone space relying heavily on this kind of essential tech?
Well, this ruling definitely raises a critical question. It's about the enforceability of these essential patents in major markets like China. For years, there's been this global debate, right, about the balance between patent holders' rights and the access implementers' need for standard essential technologies. This decision specifically, well, it could be interpreted as China signaling a more, let's say, assertive stance, kind of balancing foreign IP rights against their own domestic industry needs. It might force global tech firms to really reevaluate their IP enforcement and licensing strategies specifically within China. It suggests that just holding a patent isn't quite enough. It's practical enforceability, the local judicial view. That's paramount now. Companies licensing HEVC, they'll be dissecting this ruling for sure, trying to understand the shifts.
That's a really significant point. Makes you wonder if this could maybe accelerate the search for alternative video coding tech, or at the very least, encourage more sort of localized licensing deals. It feels like a pretty clear message for anyone operating there.
Absolutely. It could certainly spur more domestic innovation in China, maybe develop alternatives or build stronger local patent portfolios. It feels like a strategic move, It underlines just how complex international patent litigation is and how a ruling in one place can send these profound ripples across the entire global tech supply chain, potentially favoring local players, too.
Okay, so here's where it gets really interesting. The 2025 Patent 300 list just came out. It ranks organizations by their U.S. patents. Always fascinating to see who's leading, but maybe more importantly, to see the trends underneath. What were the most surprising shifts or standout performers you noticed this year, beyond just the usual top names?
Well, yeah, the usual suspects are definitely at the top. Samsung Electronics leading, it's a massive number, 9,304 patents. Then you've got LG with 5,156 and TSMC with 4,010. These numbers really just solidify their positions as, titans in the tech sector. They're consistently investing in protecting their innovations. But beyond just the sheer volume, like you said, the shifts, that's what's truly revealing about strategic intent.
And some of those shifts are quite dramatic. Huawei, for instance, saw an incredible 44% growth in their portfolio. And TCL's growth, even more astounding at 119%. That's huge. But on the flip side, Meta Platforms, Inc., Facebook's parent company, saw a sharp decline of 48%. What do these numbers tell us about, the current state of innovation and investment from these companies? Maybe their long-term strategies.
These figures offer a very clear window into those strategic shifts. Huawei and TCL's significant growth, it's not just about quantity. It suggests really aggressive investment in R&D and patent acquisition. For Huawei, you might guess they're doubling down on foundational tech thing, 5G, maybe 6G, AI patents. It points to a long-term play, perhaps strengthening their position against those geopolitical headwinds they face. And TCL's surge, that 119%, wow. That indicates a powerful push into new markets or tech areas, maybe smart homes, display tech, other emerging consumer electronics. It's a clear signal of their intent to secure future market share through IT.
And what about Meta's decline? That seems particularly noteworthy given their big push into the metaverse and AI not long ago. Could it indicate maybe a change in how they view IP? Or perhaps a different kind of strategic pivot?
Meta's decline. Yeah, it's intriguing. It could suggest a reprioritization of their patent strategy, maybe moving from just pure patent volume to a more strategic, perhaps defensive patenting approach, or it might even signal a pivot towards more open source contributions in areas like AI. That would definitely impact their overall patenting numbers. It's just a really dynamic landscape where these numbers reflect not just innovation, but also these underlying business strategies and market focus. It's not necessarily a sign of reduced innovation, just maybe a redirection of where that innovation is being protected.
Okay, finally in patent news this month. We saw the U.S. Department of Justice and the U.S. Patent Trademark Office, the USPTO. They stepped in to support patent protection for flash storage. Specifically, they backed Radiant's patent enforcement efforts. It's about tech for improved flash solid-state drives, SSDs. Why is this significant, especially for hardware innovators, particularly in critical areas like data storage?
This move by the DOJ and USPTO, it's a really strong signal, a commitment to supporting innovators in the hardware space, particularly in these critical areas like data storage, which, let's face it, underpins so much of our digital world. It definitely reinforces the idea that robust patent protection is essential. It encourages continued investment and progress in these complex tech fields. For hardware companies where R&D costs can be just immense and product life cycles are often long, having government bodies actively support patent enforcement like this, it provides crucial reassurance. It sends a clear message. Foundational hardware innovation will be robustly protected, and that's absolutely crucial for deep tech startups and established players alike, so they keep pushing those boundaries.
Okay, so while patents protect the blueprints of innovation, what about the public face of these companies? Let's turn our attention to trademarks, because this past month had some real eye-openers for brand custodians. We saw everything from new national laws to some high-stakes courtroom dramas.
Right. Trademarks are often a company's most visible IP asset, directly tied to consumer recognition, trust. Their protection is just paramount for market stability and for ensuring consumers aren't confused about where goods and services come from. Without strong trademark protection, brand value can erode pretty quickly.
Let's start with a development in Palau. We learned that Palau is advancing a new trademark act. Now, why is a new trademark law in a place like Palau noteworthy? For businesses maybe considering international expansion or investment there, thinking about brand recognition, consumer trust.
Well, what's fascinating here is seeing even smaller nations recognizing how important it is to strengthen IP protection. Trademarks specifically, it can have a real ripple effect. Palau's new Trademark Act, it aims to encourage foreign direct investment, bolster IP protection, which could make it a significantly more attractive place for businesses looking to expand their presence in the Pacific region. It really reflects a global trend towards more robust IP frameworks. Countries increasingly get that strong IP rights are a cornerstone of a healthy, innovative economy. For global brands, it means greater certainty when they enter new markets, even ones previously seen as less developed in their IP infrastructure.
That's a great point. It's not just about the size of the economy, is it? It's about the confidence that a stronger legal framework gives businesses looking to operate there. Okay, now for a case that's sparking a lot of conversation, probably because of its unique characters. The trademark lawsuit between Texas-based convenience chain Buc-ee's, famous for its beaver mascot, and Missouri-based Barkeys, which is a dog park and coffee shop. Sounds like a classic case of alleged brand and logo confusion, right? Similar names, animal mascot theme. What's truly at stake here beyond just the names?
Indeed. This case really highlights that ongoing debate. How similar can two brands be before it crosses the line into infringement? Especially when the goods or services might not be identical, but they could be seen as potentially related. The Buc-ee's versus Barkeys fight, it's a classic example of how businesses with strong brand recognition, they vigorously defend their IP, particularly when there's a perceived risk of consumer confusion in that retail and service space. What's truly at stake for Buc-ee's isn't just, this one dog park. It's about protecting the distinctiveness of their entire brand identity. which they've built through massive use and investment. The outcome will likely hinge on things like how similar are the logos visually, how similar do the names sound, and crucially, could the services offered be seen as related enough by the average consumer to cause confusion or dilute the famous Buc-ee's brand? It'll be really interesting to see how the courts define those boundaries of similarity here, especially given the different industries involved.
Yeah, it's a reminder that brand strength means vigilant defense, even against what might seem like a small, maybe unrelated venture.
Okay, and finally, a significant update from India. The Delhi High Court has put on hold its previous an order that required Amazon to pay a massive Rs 340 crore, that's roughly $40 million US, in a trademark infringement case brought by Lifestyle Equities. Wow, that's a huge sum of money to just have on hold. What does the suspension indicate about the ongoing legal battle? And what are the implications for huge global e-commerce platforms like Amazon operating across all these diverse jurisdictions?
Stepping back, yeah, this case really showcases the sheer scale and financial implications of these trademark disputes, especially for large global players like Amazon. That initial order for $40 million was certainly substantial, a big hit. The suspension by the Delhi High Court, well, it means the legal battle is far from over. It's basically a procedural pause. It allows Amazon to present further arguments or appeal the original decision. For a global company like Amazon, navigating these varied legal landscapes is just a constant challenge. This case really underscores the critical need for thorough due diligence in brand protection, especially when you're operating across different jurisdictions with varying legal interpretations, different enforcement mechanisms. It also highlights how local courts can exert significant pressure and how crucial it is for businesses to adapt their IP strategies to each market's unique legal nuances.
Okay, so from protecting groundbreaking tech and iconic brands, let's pivot now to the very essence of human creativity copyright. This is an area constantly grappling with new technologies, new forms of artistic expression. It makes it a real hotbed for legal evolution.
Absolutely. Copyright protects that creative expression, and its effective enforcement is just crucial for fostering innovation and fair compensation, both in the creative and the tech sectors, ensuring creators can actually continue to make a living from their work in this world of instant digital distribution.
We've been following the International Trademark Association, INTA. They recently gave input to the Andean Court of Justice regarding synchronization rights in audiovisual works. Okay, first, what exactly are synchronization rights? And why is INTA's input here so critical, especially for Latin America, where the creative industries are, well, rapidly growing?
Right, so synchronization rights, or sync rights, they refer to the legal permission you need to use copyrighted music or sound recordings together with visual media. So think films, TV shows, commercials, video games, even, online content. It's about syncing the audio to the visuals. INTA's contribution here is crucial because it provides detailed legal input that could significantly influence copyright protection and licensing practices throughout the Andean community, and by extension, probably much of Latin America. It helps clarify how these often complex rights should be managed, ensuring that both creators, the musicians, the composers and distributors, film studios, broadcasters have legal certainty, and that they receive proper compensation when using musical works and visual productions across the region. It's really about building a robust framework for an increasingly digital and global creative economy.
That clarity sounds vital for fostering investment, preventing disputes. Makes sense. And looking at the broader landscape, there are these ongoing discussions about copyright policies in emerging markets, with a special focus on stronger enforcement and the economic impact, particularly within the creative and tech sectors. What are the main challenges and opportunities these markets face? Balancing copyright protection with fostering local innovation and access to content.
Yeah, that raises a really important question. How do you balance robust copyright enforcement with fostering a vibrant creative economy, especially in developing regions? Stronger enforcement, on one hand, it can incentivize creators both local and international. It can attract investment into creative industries from film to software. So the opportunity is huge, right? Unlocking significant economic growth, job creation by properly valuing creative output. However, it also presents real challenges in implementation. You've got varying legal infrastructures, often limited resources for enforcement, and let's be honest, persistent digital piracy issues. The goal really is to create an environment where creators are fairly compensated, industries can thrive, contribute meaningfully to the national economy, while still ensuring reasonable access to creative works for the public. It's a delicate balance to strike.
It sounds like a constant negotiation, doesn't it, between protecting value and promoting accessibility. A fascinating challenge for policymakers everywhere. So we've covered a lot of ground today, from those global patent battles reshaping tech strategies to fierce trademark disputes safeguarding brand identity.
and the evolving copyright protections crucial for creators in our digital age. It's clear that intellectual property is just such a dynamic force. What's maybe one final thought or question you'd leave our listeners with? Something to mull over as they consider the future of intellectual property.
Well, if we consider the bigger picture, it's really clear that as technology advances, and it's advancing exponentially, and as global markets become more interconnected, the traditional lines between different types of IP patents, trademarks, copyrights, they often start to blur. So the provocative thought I'd leave you with is this. How will the increasing speed of technological innovation, particularly with areas like AI-generated content or virtual reality assets, or maybe entirely new digital economies, how will that force our existing IT frameworks to adapt, to integrate even more in the coming years? What new forms of IP protection might emerge, or need to emerge, just to keep pace with these unprecedented shifts? Will we see entirely new categories of rights, or perhaps a radical reinterpretation of the ones we already have?
That's a powerful question.
Yeah.
It suggests that the very definitions we're operating with today might just be insufficient for the innovations right around the corner. And maybe the IP landscape of tomorrow will look fundamentally different from what we know today.
Precisely. It's both a challenge and, I think, an opportunity for legal minds and innovators alike.
That's all for this episode of the Tejswi IP Show. We really hope this review of the latest IP news has given you valuable insights and a lot to think about.
Thanks for listening. Stay tuned for more upcoming episodes.
And for reliable and expert intellectual property legal services, contact TEJSWI IP today or log on to www.tjswipe.com. Our team of experienced attorneys is dedicated to helping individuals and businesses safeguard their intellectual property rights in the digital age.